Okay. Welcome back to the speaker series of the Center for Criminological Research. We are extremely excited to start into another exciting year here at the CCR and to have our first speaker kick off this year's series. Before we introduce today's speaker, I would like to start us off in a good way and acknowledge that the Center for Criminological Research and the University of Alberta, its buildings, labs, and research stations are primarily located on the territory and lands that are known as part of Treaty 6, 7, and 8 and homeland of the Métis. So the University of Alberta respects the sovereignty, lands, histories, languages, knowledge systems, and cultures of all First Nations, Métis, and Inuit nations. And so with that, I'm going to give it over to Emily Stewart, who is going to introduce today's speaker.
Okay, I hope everyone can hear me. But it's my pleasure to introduce César Garcia Hernández, a professor of law at Ohio State University, where he holds the Gregory H. Williams Chair in Civil Rights and Civil Liberties. His work examines the intersection of criminal and immigration law, and he's the author of several influential books, including Crimmigration Law, Migrating to Prisons, and most recently, Welcome the Wretched. His work has shaped critical conversations about immigration enforcement and criminal justice in the United States. And today he will be discussing how the Trump administration has turned the Alien Enemies Act into key features of its rhetoric around migrant criminality. So please join me in welcoming César. I know that we are all looking forward to your talk this afternoon.
Great. Thank you so much for having me. It's really a pleasure. It was a pleasure to get the invitation to join you on. It's a pleasure to actually be here with you all. And to do so, especially in this particular political moment, so much of what is happening in the United States right now is focusing on rewriting the norms by which those of us who live and make our lives in the United States live by. And one of the things that has already struck me is the simple fact of acknowledging where it is that I'm presuming most of you are gathered, or at least the university is, in Sandra's opening remarks. Land acknowledgements at the university that I work at, Ohio State, are actually now prohibited. We are now permitted to acknowledge the fact that there were once people who made their homes in the place that is now called the state of Ohio, and who were forcibly displaced through the fact that the university, being one of many land grant universities across the United States, was funded in its earliest days, primarily, or at least substantially, from the proceeds of sales of land that was taken from Native peoples, and actually not in Ohio, but in the western part of the United States. That money then funneled back into the university's endowment, an endowment which continues to fund the work that I and my colleagues do. And so everything that we do seems these days to be inflected by an attempt to rewrite norms. And so that's why when I was thinking about what it was that I could share with you, the Alien Enemies Act was the thing that came to the front of my mind, because this is one of those features.
César,
Yeah.
I'm sorry to interrupt. I'm just not sure if you're aware that your notes are actually on the screen as well.
My notes are up there. Oh,
yeah.
sorry.
Sorry to interrupt. I wasn't sure if you knew that. Yeah,
no. And actually, those are not even the notes. I actually can't find my notes. This is what I was looking for. Those are notes for a different talk that I did a few weeks ago. So I'll just look at I'll just put up the slide. Are you seeing the slide now? Yeah. Okay.
Yeah. Yes.
So one of the things that sorry, before we get that, one of the things that the thing that came up to me to my mind was the Alien Enemies Act, because it is a feature of the earliest days of the U.S. legal system that was dormant for much of the last 2 centuries, in which we're now seeing revived in a particularly a forceful fashion. But before I do turn to the substance of the Alien Enemies Act, the way that it's, I think, infecting the criminalization of migrants these days, I want to turn to a little bit of an overview of what's happening at the Supreme Court, because several of the cases that I'm going to talk about from the last few months are decisions of the U.S. Supreme Court. But one of the oddities of the Alien Enemies Act is that it is being revived in a moment in which the U.S. Supreme Court has altered the typical means by which we see decisions issued by the court. The ordinary process by which the court renders decisions is a lengthy one. It usually takes years between the moment in which a lawsuit begins in some district court somewhere in the United States until the time that the Supreme Court justices actually publish a decision with a final ruling that is no longer appealable and applicable throughout the United States. And the commonly known features of that is argumentation in front of the justices and lengthy decisions, lengthy opinions, opinions that I wish were quite often were much shorter. Sometimes justices, I think, could benefit from working with a good editor, but they don't. And that's the process that we have grown accustomed to. And in those, the upside is that we understand exactly how they got to the decision that they did. And what we're seeing these days, and what's in a way that is highly relevant to the Alien Enemies Act, is that the court has begun to deviate quite regularly from that ordinary merits-based review process that we're anyone with any glancing familiarity with the U.S. Supreme Court is familiar with. And instead, the court has devoted a lot of its work over the last several months to cases that arise on what sometimes we call it the emergency docket. Some folks, I write for a website called SCOTUS blog. They call it the interim docket. And then the catchier, but a little bit pejorative a term is the shadow docket. So if you've heard of any of these phrases, they're all referring to the same thing. I usually refer to it as the emergency docket, because the idea is that this is supposed to be a pathway by which cases of utmost urgency reach the justices on some preliminary procedural issue, typically, and the justices then weigh in. Usually, the request is to issue a stay of some lower court proceeding that's pausing implementation of a lower court's order. It can favor either side, of course. But the core character of the emergency docket is that it's fast. To be fast, you cannot. It's very hard to be fast. And those of you who are writing as part of the research that you're doing know that you can't be fast and thorough. One thing has to give. And the Supreme Court's ordinary merits process is thorough, but not fast. Well, the emergency docket is really the opposite. It's very fast, but not thorough. And so what that looks like is that we get these decisions from the justices that are issued literally within months of the lawsuit beginning, typically beginning in some federal district court somewhere. The cases that I'll be talking about begin in a federal district court in various corners of the United States. And within a few months, we have some decision from the Supreme Court. Now, in order to be that fast, to act that fast, most of these orders are extremely superficial. They run a number of paragraphs, 3-4 paragraphs long. Sometimes there have been orders that number when it comes to the number of sentences, we're talking about 7-8 sentences long. Most of that is very procedural in nature. So the sentences themselves are cut and paste jobs from prior emergency docket orders. And what that means then, for those of us who are on the outside of the Supreme Court trying to make sense of what the court's decision means, it's really hard. We don't have the benefit of the court's reasoning, of the justice's reasoning. Often, we don't even know how many justices participated in the decision-making process. They don't tell us who voted in which direction. And so we have to guess, essentially. And as a result, for lower court judges, as well as the lawyers, the parties, right, are trying to understand how a Supreme Court decision that numbers just a handful of sentences spread across a few paragraphs, how are we supposed to interpret this? Well, we're left grasping for theories, right? We're left grasping for assumptions, trying to imply some reasoning into the limited text that we get from the court. And this has come up a number of times already in the Alien Enemies Act context. And I'll share some of that when I get to the judicial interventions that we've seen. But to jump to move into the law itself that I want to draw your attention to. So here a couple of just quotes from two of the current sitting justices on the court, right? They're telling us the way that the Supreme Court is persuasive is through its reasoning. And so Justice Amy Coney Barrett says in a public interview that she did a few years ago, read the opinion. And it's really encouraging people to take as their civic responsibility digesting the words that the court uses and trying to make sense of that. And this is her attempt to defend the court against claims of ideological decision making. More recently, Justice Sonia Sotomayor says something very similar. Read the decisions. She says it's actually this summer when she's being interviewed on Stephen Colbert's show. So extremely high profile audience there because of Colbert's reach. So very similar sentiments by two justices that ideologically are not often on the same page, but both of those sentiments are subverted by the fact that in these emergency docket cases, we typically don't have opinions to read. We don't have decisions to make sense of, and so the court is currently grappling with this perception problem that is growing, while at the same time, I think feeding into it by limiting the amount of its rationale that it is willing to share with the public, and all we get then is a very perfunctory explanation of what is the decision. Are we going to pause implementation of a lower court order or not? But we don't know why. The rest of us who are outside the court don't know why. So when it comes to the Alien Enemies Act, is a statute that's been on the books since the late 1700s. It was enacted in a period of time in which there was a very small number of federal laws that were enacted in the late 1700s, in that first moment after the British colonies successfully secede from the English crown, and are starting to form the United States. And this period of time, the first Naturalization Act in the history of the United States is passed by Congress that limits naturalization to, in the words of the statute, free white persons. And then this is one of the few other statutes that is enacted during that period of time, and the only one that remains in force today. The Naturalization Act is no longer in place. But the Alien Enemies Act is. Right? And as you can see here, right, it provides multiple venues or multiple pathways that serve as triggers: a declaration of war, or the existence of an invasion or predatory incursion. And those, if those exist, then the president can issue a formal announcement through a public proclamation that the United States is going to target the citizens of a particular country, as long as they are at least 14 years of age or up, for detention and potential removal. Right? This is the way that the federal law authorized the president to announce that there are alien enemies potentially in our midst, who the president has elected to target. And so what we've seen recently is that, of course, the president has decided to target folks from Venezuela. This is not the first time that the Alien Enemies Act has been used, but it is the most recent. In the past, we've seen it at play on 3 occasions. One during the War of 1812. There was a declared war against Britain, and then the second time was during World War I. Third time during World War II. And during each of those past instances in which the Alien Enemies Act has been used, well, actually, before I say that, I want to be clear about the World War II instance. Obviously, during World War II, one of the dominant features of domestic enforcement of people who the federal government had declared to be suspicious was the massive internment of Japanese citizens, as well as U.S. citizens of Japanese descent. Most of that detention actually did not occur by virtue of the Alien Enemies Act. There was a separate executive order that was signed at the time, as well as a separate statute that the federal government used at that time. So mostly it was not responsible for that massive internment targeting people of Japanese descent. But nonetheless, it was used during World War II as well. And so in each of these past instances, 3 past instances, there have been challenges to the way in which the president has or the fact that the president has sought to invoke what is a fairly broad statutory authority, and by and large, the courts have been pretty receptive. In those instances, the courts have been pretty willing to defer to the president's authority to use what is admittedly a very broad power that Congress has given to the president, as the court said as early as 1814. This is a very great discretionary power the statute gives to the president. But Congress is authorized to do that, and has done so through the Alien Enemies Act. Importantly, this isn't just a lot of discretion that the president has to decide when to invoke the Alien Enemies Act. The courts have also interpreted the power that the Alien Enemies gives to the president to be broad once that invocation happens, and part of that is temporal. For example, in 1948, in this Ludecky versus Watkins decision, the court made it quite clear that the use of the Alien Enemies Act is not limited to those instances in which there are actual military hostilities going on. Now, let me actually jump down to the last point that I make there, the political question issue. I think this is something that will certainly continue will rear its head again if we get to a point where the Supreme Court weighs in on the merits of the Alien Enemy Act's use in current days. Courts have not had too many instances to weigh in on whether or not there is review possible by the judiciary. But in those rare instances, they have tended to decide on this, or to come down on the side that there is not. That the question of whether an invasion is ongoing is not something that the courts should decide, because it's much more of a political determination than it is a legal determination. This case that's cited there by the U.S. Court of Appeals for the Ninth Circuit, it's actually an argument that California was making, that migrants were invading the United States. And the Ninth Circuit's position was, look, the president hasn't said that migrants are invading, and therefore we have no authority to second guess that. Right now, in the situation we're facing now is sort of the inverted, where the president says there's an invasion, and so the lawsuits that I'll talk about in a few minutes are basically making the point that's not true, and so the courts then are having to grapple with this question of whether or not they have any role in second guessing. Back in 1996, the Ninth Circuit's position was no, we don't have a role. So, of course, in order to determine whether an invasion exists, we have to know what invasion means. The other alternative to invoke the Alien Enemies Act is that there's a predatory incursion going on. Well, that requires that we know what the phrase predatory incursion means. And here, in the past, there's been very little, well, there's been no reason for the courts to tell us what these phrases, what this word invasion means in the context of the Alien Enemies Act, or the phrase predatory incursion, because in each of the last of the prior three instances in which a president has invoked the Alien Enemies Act, there has very clearly been a declared war in place. In the War of 1812, that was a declared war against Britain. World War I and World War II, again, instances in which there was undeniably a declaration of war by the Congress of the United States. And the Constitution gives Congress the power to declare war, and only Congress. And so courts didn't have occasion to weigh in on whether there is an invasion or a predatory incursion ongoing. And so they didn't. And so now we're having to figure out, well, what do those terms mean? Because we're currently dealing with a situation in which there is obviously not a declared war, well, with anyone. So and certainly not with any migrant population. All right, so fast forward to March of this year, President Trump issues this proclamation invoking the Alien Enemies Act regarding the invasion of the United States by Tren de Aragua. Well, Tren de Aragua is a gang originated in the Aragua region of Venezuela that was really unheard of in the United States up until very recently, up until about a year and a half ago. Almost no one had heard of Tren de Aragua. I certainly consider myself in that camp. There was plenty of conversation in the United States, and has been for many years, about transnational gangs that really rise up somewhere in Latin America. But when we talk about these transnational gangs, up until very recently, we were talking about MS-13, Mara Salvatrucha, primarily Barrio 18, which is another Central American, another gang that really took hold in Central America. To a lesser extent, primarily these were conversations about MS-13. Tren de Aragua doesn't really come to prominence until really about 2023, midway through 2023. At this point, we're seeing tens of thousands of people arriving in the United States from Venezuela, specifically every month. It's a large exodus given the deteriorating situation in Venezuela. And so we start to hear concerns about this gang, and we start to then and we see that President Trump, when he's campaigning during his second, what ends up being his second successful run for the presidency, latches on to Tren de Aragua as a rallying cry. And specifically, he focuses on a city that I know quite well, Aurora, Colorado. It's a suburb of Denver. It's sort of very much a working class suburb of Denver. As the city center, that's Denver, has gotten more expensive. Most of the city is quite unaffordable for working class individuals, and that certainly is true of recent arrivals, migrants from Venezuela or otherwise. And so Aurora is one of the suburbs, it actually neighbors Denver, that is much more affordable and has become very diverse, racially diverse, linguistically diverse. The national origins of the population has become much more diverse, and it is economically still much more within reach for working class individuals and families. And so there's an incident around the last presidential election in Venezuela, in which folks gather in a parking lot to celebrate what they view to be Maduro's loss in that election. Obviously, Maduro doesn't leave power, but folks gather on election day in this parking lot, and then several hundred people, and it's a celebration. It's loud, it's boisterous. There's honking, there's families, there's everything that goes along with a political celebration is happening there. Well, folks leave, and it's dirty. There's trash strewn around. The mayor of the city, Republican, former member of Congress, criticizes the folks who attended, and does so quite prominently in local media. And then shortly thereafter, video surfaces of some armed men who are storming through an apartment complex, a rundown apartment complex in Aurora, banging on doors. What is a very frightening looking recording. A local member of the city council in Aurora then jumps all over this, starts to promote it through right-wing social media networks. This is a member of the city council who's very much aligned with Trump's ideological positions, and that eventually lands on Fox News and other right wing, even further to the right, national media outlets. Well, shortly after, Trump embraces this. He starts talking about Aurora as having been overrun by criminal aliens, and promises that if elected, he's going to launch Operation Aurora to target migrants around the United States, who he claims are doing these diabolical things, and eventually flies to Aurora as a campaign rally. This is now very much in the midst of the election against Kamala Harris, and obviously, yeah, he wins the election, and just within a few months issues this presidential proclamation saying we're going to target members of Tren de Aragua, who are citizens of Venezuela, at least 14 years old, and not dual citizens, not the citizens of the United States or permanent residents of the United States. We're going to detain them, and we're going to remove them, and we're going to do so under this power that the Alien Enemies Act gives us, and so we start to see that Department of Homeland Security officers start to do exactly that. They start to implement this. In fact, we see that they start to implement this shortly before the presidential proclamation is actually publicized. Apparently, DHS knew that this was happening, that the president was about to sign this order, and started preparing by moving folks who fit this description, or who they thought fit this description, into a single detention center in South Texas, where there's a nearby airfield in Harlingen, Texas, around the southeastern tip of Texas, from which deportation flights regularly depart. And so we see that they start gathering people. Well, almost immediately litigation begins, and in that litigation is going in multiple directions. First, beginning with this April challenge to the government's use of the Alien Enemies Act, in which the Supreme Court, through its emergency docket in April, actually sort of sides with migrants, saying, look, the federal government is making this claim that once the president issued this proclamation, there's no role here for the judiciary. And the Justice Department's lawyers are very clear. There is no role for the courts. The courts have nothing to say. They have no role in deciding whether the AEA is properly invoked, whether we're doing this right, we're doing this wrong. There's just no judicial review. Justices don't fully buy that. And that much it is not surprising. The judges are not accustomed to taking kindly to claims by the executive that they are irrelevant. This is it's pretty unusual for the courts to give complete discretion over to the executive with no role whatsoever for the courts. And so in April, they hold on to some power. And in May, what we see there is that the government is trying to remove people extremely quickly using the Alien Enemies Act, handing them a document notifying them of the government's intention, and sticking them on an airplane within less than 24 hours. This sort of builds on that Trump versus JGG decision, because of course, if migrants can challenge the government's use of the Alien Enemies Act, they have to have time to do that, right? And so the Supreme Court says, like, you have to give people more than 24 hours. They don't say how much time you have to give them. You have to give them at least 24 hours so that they figure out whether they can challenge it. Like, do they think they have a legal basis? Do they want to challenge it? And of course, can you? It implicates, do you have access to counsel? There is no right to appointed counsel in these proceedings because these are not criminal prosecutions. They are civil lawsuits that the individual migrants are choosing to bring. And so actually going to court requires having access to a lawyer who's going to work for free or who you're going to pay. Well, the first time and so far the only time that a court has weighed in on the substance of this decision is in September, where the U.S. Court of Appeals, which is the most right-wing court in the United States, federal appellate court in the United States right now, actually sides with the migrants on the merits. Those first two cases those instances in which the Supreme Court weighs in, those are really procedural questions. But this decision from the Fifth Circuit is much more of a direct assessment of whether the president has the authority to actually invoke the Alien Enemies Act under the present situations. And the court says that it actually defines those terms, invasion and predatory incursion, that courts had not had occasion to do so in the past. And says, look, if we compare what these terms mean, basically some kind of coherent, organized, hostile military force, or a threat of that. We compare those definitions to what's happening on the ground. They say these things don't match up. But what sounds like a win for migrants, and to be sure it is, isn't necessarily a lasting victory for migrants. But what the Fifth Circuit also says is we're not going to second guess the facts as articulated by the president in his presidential proclamation. We are going to take those factual assertions as true. Right? Now, one of the things that President Trump is prone to do is invent facts. And so this posture, this completely deferential posture regarding the factual assertions, the court in fact places that sort of credits those factual assertions in its analysis. Ultimately concludes that they don't even if we believe 100% of what the president said in his March proclamation, doesn't rise to the level of invasion or predatory incursion. Right? So that's where we are right now. Moving forward, the president could take the Fifth Circuit's position of complete factual deference on the facts and issue a new one, a new proclamation that does satisfy the definition of invasion or predatory incursion. Just make things up. The military of Venezuela is on its way to the U.S.-Mexican border. Right? If we take at its words the Fifth Circuit's explanation that it must defer to the factual assertions as found by the president, then there's no stopping the inventiveness with which an invocation of the Alien Enemies Act could be launched. Now, the alternative to that is declaring war. Congress can do that. That's a political determination, not a legal determination. Congress wants to declare war on Venezuela or Tendarawa, Congress can. And certainly President Trump has plenty of allies in Congress that so if they were to choose to do that, I have any reason to suspect that that attempt would fail. And what we're seeing on the ground and in the water, I suppose more literally, in recent weeks, is certainly suggesting that we could be moving in that direction. There's more and more of a U.S. military presence in around Venezuela, perhaps already in Venezuela. Some of these, the president said that he's authorized the CIA to engage in covert operations targeting Venezuela. And the president has already said that he has determined that we are in a formal military confrontation with drug trafficking terrorist groups, as he's described them. Might that form the substance? I haven't seen the Justice Department to litigate that just yet, but that's something that may be on the horizon. Now, this risk is very much real and not a new concern. In the very earliest case that I've been able to find from a justice of the Supreme Court, weighing in or sort of considering the Alien Enemies Act, the court recognized this back in 1799. That the Alien Enemies Act, because it is so broad, because it gives the president this really quite remarkable power to detain and deport anyone who fits the criteria that's specified in the statute, can be abused, right? And so the fact that we are now contemplating whether it is being abused in this context is something that is should perhaps not be surprising. And so as I think about it, it's broader, the broader implications of the president's use of the Alien Enemies Act. I'm left I constantly come back to the idea that of sovereignty. I mean, these are all these claims about needing to protect the United States, needing to protect the United States against these so-called criminal aliens, against people who the president has identified as terrorists, is justified by the jurisprudential embrace of sovereignty as justification for remarkable latitude to enforce immigration law as the executive sees fit. And to me, that rings of the version of sovereignty that Carl Schmitt, the German philosopher, who was a prominent figure of the Nazi jurisprudential circles, articulated about a century ago. The sovereign is he who creates the exception. I'm paraphrasing a bit there. The sovereign is he who creates the exception, and the exception the sovereign gets to decide to what extent the law applies. And I think that's exactly what we're seeing in this particular situation of the Trump administration's use of the Alien Enemies Act. The idea that the courts have almost no role, right? The idea that using the Alien Enemies Act can be justified or can be permitted, according to the Fifth Circuit, under factual claims that are divorced from reality, as long as the president formally makes those assertions. To me, is an illustration of the fact that this notion of sovereign entitlement to control cross-border movement by people can be wielded at the discretion of the federal government to whatever extent the federal government wants. And what we're seeing these days is that the federal government's approach is to tar migrants, especially migrants of color, specifically in this context, citizens of Venezuela, as inherently dangerous, as a threat to as an existential threat to the United States, not simply a threat to one person or another person, not simply targeting of specific individuals. The very presence of migrants from Venezuela is itself being framed as an existential threat to the security of the United States and therefore to the existence of the United States. And as a result, the president has chosen to invoke this amazingly broad power that, while it's being contested, certainly not those challenges have certainly reached no resolution. So I fully expect that this will get back to the Supreme Court. And once it does, we can only wait to see how the court weighs in when it does. But I'll stop there. I'm happy to take some questions at this point. And if you want to learn more about any of my work, that's where you can find me.
Thank you so much. I'm going to just open up the floor. This was super interesting, especially for us here in Canada. We obviously pay a lot of attention to US politics, but I think the questions that we'll be having are probably going to be from a more Canadian perspective. I don't know who wants to start us off. I know Kevin has a question. I don't know if anyone else does. If so, just raise your hand. I will try to navigate this here on the Zoom call. So Kevin, just you're first up.
Okay, thanks, César. That was really fascinating. You can hear me?
Yes.
Yeah, great. Sort of taking it, you're framing this as a legal thing, and I just wonder if this is ultimately a political thing, and this takes you a different direction. I wonder if one of the things that Trump has done, you can see this as a good thing maybe, is that he's dropped the shackles off any pretense that the Supreme Court is anything other than a political entity. There's these facades of legality, but certainly Trump, everything he does, he talks about Republican courts and Democrat courts, and I mean the entire pretense that the court is a disinterested legal body seems to have evaporated.
Yeah, when your question makes you think of some of the early 19th century decisions from the Supreme Court, in which the court says that the proper government unit to regulate cross-border movement of people through immigration law is the federal government, and specifically the court repeatedly says the political branches of the federal government, meaning the president, executive, and the legislature, right? The third branch being apparently not political, right? The judiciary being not political. I think you're actually spot on. The complication is that that Trump, when he's talking about these the courts, I think the strategy from the Trump administration is that they are going to lose over and over and over and over again at every single level of the judiciary, up until they get to the Supreme Court, right? And in that sense, I'm not really sure how that plays out, because they are losing in front of Democratic appointed judges. They're also losing in front of Republican appointed judges. Certainly, justices appointed by Republicans who are not named Donald Trump. They're also losing, not as much, but they're also losing against Trump-appointed judges who are not on the Supreme Court. The judge in Oregon, who has barred the administration from deploying the National Guard to war-ravaged Portland, Oregon, for example, was appointed by President Trump during his first term. And so I think we are seeing a little bit of a complication of this I think intuitively appealing view that judges operate in an inherently ideological fashion. I think it is ideological, but it's also partly ideology as conveyed through acculturation. Judges are socialized into legal norms as much as they are trained in the substantive legal prohibitions and legal permissions. And one of the things that judges find appalling is the notion that they don't have a role, that the president ought to get to make whatever decisions without anyone second guessing those decisions. And so I think this is where some of the source of some of the pushback comes from. Now, when you get to the Supreme Court, I think that's a completely different ballgame. Those folks are political. In order to get appointed to a position on the court, you have to be a political beast. You know, you have successfully navigated what is an inherently political process, and you have done it for quite a long time in your life in order to get that nomination. And so I think we are seeing the Supreme Court really disrobe itself of any claims to operating in a non-political fashion, whereas I think we're seeing that play out in a somewhat more of a complicated way at the lower courts still to this day.
Thank you.
If you have questions, please put your virtual hand up. So if there's no one else right now, I'm just going to jump in. So if the courts eventually label invasion as justified, as a concept that we simply have to accept, could that not activate, I guess, the wartime authorities down the road? Because you're then essentially in a situation where you can label undocumented immigration or cartel activity or whatever as an invasion, which would trigger war or emergency powers, I assume, in the US. And is there, I guess my question is a legal one, is there then, once that is in place, any legal mechanism that could stop that sort of like trickle down effect?
I don't know. I don't know the answer to that. I mean, at first, I don't know because I'm not actually a specialist in military law.
Sure.
Right? I mean, I think that's the
Yeah.
easy answer. The hard answer is I don't know because we've never had to face this. I mean, that's the unprecedented part of this, right? Trump is expert at nothing if more than pushing the boundaries of what's permissible until forced to do otherwise. And so the mere fact that is exactly the kind of question that we're starting to ask now is a great source of concern on a very personal level. When the I didn't talk about the Fourth Amendment stuff that's been happening, but when the Supreme Court permits immigration agents to go around targeting people because of the language that they're speaking in public, because of their apparent race or ethnicity, because of the type of work that that immigration agents think that they do in the location where they happen to be found, that is pushing the boundaries of what's permissible. It's inviting racial profiling, right? And so these questions of what is it that we can do? Is there a legal means of stopping the use of military forces within the United States? I mean, the Supreme Court is currently grappling with that. One of the cases on its emergency docket is a request right now, is a request by the administration to permit it to deploy National Guard troops into Chicago. That has been a federal judge in Chicago stopped the administration from doing that. That has been fully briefed now on the on the emergency docket. And then 2 days ago, the Supreme Court asked the parties to submit supplemental briefs on a specific question related to this. So it seems like they're taking this question seriously about whether they're going to weigh in. They're doing it again on the emergency docket, which means that we may get a decision that just numbers some sentences in which the sentences are just numbered in the single digits, and where we don't really know what's going on in their minds. So why are they thinking this one way or the other? I don't know whether they're going to say, yes, you can send the troops into Chicago, or no, you can't. But whatever it is, if we don't have text, then we don't know why they make whatever decision that they make. And so I'm fearful that we may have a practical answer to this question without understanding that answer.
Yeah, thank you. That's excellent, and I think that is exactly what's going on. There's no precedent, right? Okay, Justin, your turn.
Thanks so much for your talk. I just had a quick question, I guess, if you had any thoughts on the government shutdown and how it might relate to the elements you've been talking about. I mean, to me, it seems like there's a strategic element in a lot of what you've been discussing, is a lot of strange strategies used by the administration in trying to get outcomes that they want. So I guess I'm just wondering if you had any thoughts about the government shutdown as it might or might not relate to all this.
Yeah, well, members of the military, as well as members of the Department of Homeland Security, law enforcement staff in the Department of Homeland Security, both within the Immigration and Customs Enforcement Agency, as well as the Border Patrol unit of the Customs and Border Protection Agency, are all essential workers, and so they are going to work as usual. In the past, when that's happened, they haven't been paid. So eventually, they start being unhappy about that. As you can expect, there's been some unprecedented manipulations of money, including apparently a private donation of like $150 million to help pay some of these folks, both in the military and within the Department of Homeland Security, during the current shutdown. So some of those folks are still being paid, yeah, this is the shutdown is worrisome on a number of levels, but this sort of plucking of favorites is concerning, on top of just the regular concerns about the continued shutdown, because of course that's a way of winning over people, winning over the law enforcement staff, that the administration is relying so heavily on, especially given their willingness to invoke things like the statutes like the Alien Enemies Act, because this is such a broad authority that is being granted to the president. It is potentially usable across the United States. And so you need to keep on your side the folks who are actually going to go out into the streets and find people and arrest people, and process them for deportation and get them onto airplanes. And I think what we're seeing right now is that the administration is being very sophisticated about how it is playing the shutdown to its favor, to leave no doubt that the vast majority of federal government employees are not its priority. Its priority are the folks who carry guns, whether they're in the military or whether they're in the Department of Homeland Security. They're increasingly wearing uniforms that look very similar to one another, and they are carrying weaponry that looks very similar to one another. I mean, the scenes that we're seeing in communities big and small. Yes, Chicago, LA. I live in Denver, so I've paid attention a lot to what happens in Colorado. In Durango, Colorado, small town in the southwestern corner, in the mountains, the southwestern corner. Lovely place, very small. They just were pepper spraying people who were peaceably sitting in front of a gate that provides access to an ICE office building, because ICE arrested the father and his two teenage children as the father was taking them to school that morning. So residents essentially were protesting, sitting in front of the facility, trying to prevent ICE from removing people, specifically his family, from this facility. And ICE agents started walking around, pepper spraying them. There's video of one person, a middle-aged woman, who's filming, and everyone's filming, right? So everyone's recording, so you can see the person. Somebody else is recording the woman recording, and she's recording an ICE agent saying not nice things to him, but not touching him or blocking him. And he loses his patience. Eventually takes the phone away from her. She doesn't. She continues saying more colorful things, and eventually he just grabs her, throws her onto the ground, violently. And yeah, those folks not only need legal impunity, they're not doing this because they're bored. They're doing this because it's their job. And so I think the administration is really doing itself a favor by playing the funding that it does have available during this shutdown in a way that is making friends of the folks who it relies on to carry out its priorities.
Thanks so much. Yeah.
I know we're over the hour. I would be really interested if there's someone who's actually interviewing these ICE agents. Are you aware of any studies going on? No. Okay.
No. I mean, even before this, they're not fans of speaking to academics.
Yeah.
What you can see right now are a lot of recently fired or retired ICE agents, including from Trump's first term, who are speaking out. But no, they're not talking.
Yeah. No, I figured. It's gonna be interesting even to talk to retired folks. But yeah, I know we're over time. Thank you so much, both for your talk and for engaging with us in the Q&A. As we said, we will, if that's okay with you, we typically post it on our YouTube chat, and then sometimes you might get questions from people who watch the talk, if that's okay with you. But again, thank you so much for sharing your research with us. And for everyone who's watching, our next speaker will be on November 14th. So that is in just 2 weeks from now. And it's going to be Dr. Poppy Begum from St. Louis University. And the title of her talk is "What's Love Got to Do with It? Criminal Records, Second Chances, and Dating After Incarceration." So I hope to see many of you in 2 weeks. And thank you again, César.
Thank you all. Take care. Have a good day.
Thank you. Bye.
Bye.